Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. A lot of times people will hear lawyers in court say, Your Honor, just for the record, just for the record. Well, what does that mean, just for the record? There's sort of a superficial meaning and then the real meaning of it, right? For the record, everything that you say in court is going to be for the record, right? Especially in felony cases, of course, there's going to be a court reporter, also known as stenographer, if you're like 100 years old. But there's going to be a court reporter that takes down everything that's said, and that is the record, right? But when a lawyer says, Your Honor, for the record, it's sort of like, it's a term used to signal to the judge and to the prosecutor that you are making a statement to preserve an issue or to just be able to make an argument that maybe it's not going to be received well, but you're doing it because you're trying to preserve the record. And what does preserve the record mean? So when we say preserve the record, what we're talking about is if down the road, right, we don't know how the case is going to proceed, obviously it depends on what stage you're in, but if down the road there's ever a conviction and then there's going to be an appeal, let's say, for example, the lawyers that handle the appeal, the justices potentially at the Court of Appeal level, are going to review the trial court record. And so when I say for the record, I am signaling to the court and to the prosecutor that I am making a record for potential use down the road if it were to ever become necessary. And again, it's really not necessary to say that, right? Because of course, again, everything's being recorded. But again, it's just a way to let other people know that you're making the argument for a particular reason. And frankly, there are times when I will say for the record, or I will make an argument for the record, and I may not even know if it's an issue worth preserving, right? Or I don't even know if the law is really on my side as far as making this argument. But I'd rather make an argument, again, within reason, with obviously some understanding of the issues, than not make an argument and then lose an ability for my client, if things were to go poorly for him or her, to make that argument down the road if the case would ever be appealed for some reason, right? So I want to preserve the record. And again, I'd rather be wrong about the issue or the argument I'm making than not make the argument at all and then lose, again, an opportunity for my client or close the door to a potential option down the road. Okay? So when you hear people say for the record, that's really what's going on. Hopefully this gives you a little bit of insight and it's somewhat helpful. If you have any questions, please leave them in the comments, or of course you can give us a call. Again, my name is Stefano Molea. I'm a partner here at the law office of David P. Shapiro. Our phone number is 619-295-3555.